I am an attorney with Colorado Legal Services. You are probably here today because you are facing eviction. An eviction is also called a forcible entry and detainer action, or FED. Here we will call it an eviction. Any court case can be complicated and tricky to understand. It is best that you try and speak to a lawyer before you make any agreements with the landlord and/or before you go to trial. Also, please understand that the content of this video is legal information, not legal advice. In this video, we will discuss the following 9 topics. 1. Overview of evictions. 2. Eviction notices. 3. The landlord starting an eviction case. 4. Defenses to evictions. 5. Going to court. 6. The answer form. 7. Settlement agreements. 8. The trial. And lastly, 9, appealing the court's decision. Now let's start with the first topic, overview of evictions. Eviction is the legal process in which a landlord removes a tenant, also called a renter, from a rental property. Not only does being evicted leave you without a home, it can also have a negative effect on your credit and your future ability to rent a home. Evictions occur for many reasons, such as not paying rent, violating a lease, failing to leave at the end of a lease, or participating in illegal activities. In order for a landlord to evict a tenant, the landlord must strictly follow eviction laws. If a landlord does not follow these rules and procedures, the eviction case might be dismissed. If this occurs, the landlord will have to start the eviction process over again. Second topic, eviction notices. The first thing that happens in an eviction case is that the landlord gives the tenant a notice or a demand in writing. This notice or demand usually tells a tenant that they have a certain amount of time to either fix their violation or leave the home. This notice must be in writing. It must give the reason for the eviction or the violation. It must describe the rental property. The notice must also give a date by which the tenant must take action, which means the tenant must either follow the rules in the lease or leave the property. This notice must have been signed by the landlord or the landlord's agent or attorney. It must be either hand-delivered to the tenant or posted on the door of the rental property. The amount of time the tenant is given in the notice depends on the type of alleged violation. Typically, an eviction notice for non-payment of rent or a demand for compliance with the lease, which is where the landlord demands you follow the rules in the lease, usually requires 10 days notice. An eviction notice for a substantial violation, such as violence towards another tenant or other criminal activity at the rental property, requires 3 days notice. A notice involving a mobile home that the tenant owns requires 30 days notice. However, these rules regarding notice have been changed temporarily in response to COVID-19. As of this recording, landlords are required to give 30 days notice to tenants who were late on their rent before starting a non-payment eviction, but this requirement is likely to expire. Please consult with an attorney to see whether this requirement applies to you. Another type of notice is a notice to quit without cause. This is used when a lease ends and is not being renewed by the landlord. The time given to a tenant to move out of the home for a notice to quit without cause depends on the length of the lease. For example, if the lease is for 1 year or longer, the landlord is required to give notice to the tenant 91 days before the lease ends. However, if the lease has a specific end date and does not include a rollover provision, then a notice to quit is not required. An example of a rollover provision would be a sentence in a 1-year lease that states at the end of the term, the tenancy automatically turns into a month-to-month tenancy. Let's look at an example involving non-payment of rent and notice. In the case of non-payment, a landlord is usually required to give the tenant a 10-day notice or demand. The notice should state that the tenant has 10 days to either pay their rent or to move out of the rental unit. If the tenant does not pay rent or does not move out, then the landlord can file an eviction with the court. Third topic, the landlord starting an eviction case. The landlord will file in the county where the property is located. The landlord will then serve, or in other words, give, the tenant with a summons and complaint, either by hand delivering that paperwork or by posting it on the door of the property and mailing it to the tenant. The summons gives you, the tenant, the date when you have to go to court. The court date cannot be less than 7 days or more than 14 days from the date the summons was served on you. The complaint tells you why the landlord is evicting you. It may claim that you also owe the landlord money and list how much that might be. If you have been served with eviction papers, your landlord is claiming that they have a reason to evict you. But you may also have a defense of the eviction action that would require the judge to make their decision about the case in your favor, therefore allowing you to remain in your home. Fourth topic, defenses to an eviction. Defenses to eviction actions can include the following. You did not violate your lease. You cured, or in other words, fixed, the alleged lease violation. The violation of the lease was minimal. The landlord waived the right to end your lease, such as by accepting payment of the next month's rent after the alleged violation. The landlord is retaliating against the tenant. The tenant is a victim of domestic violence, or local, state, or federal fair housing protections are involved. Please note that needing more time to pay the landlord is not a defense to an eviction. The judge will be required to rule against you if this is your only defense. Fifth topic, go into court. After you have been served with court papers, you need to go to court on the date and at the time stated in the summons. This is called the return date. Once you are in court, you will be able to file an answer, or you may enter into an agreement with the landlord. An answer is a form that you can find in the clerk's office or on the court's website that you use to explain your side of the story, including any defenses you may have. If you do not do one or the other, or if you do not show up to court at all, the judge will enter a default judgment against you, meaning that you lose the case and will be evicted. You will then have an eviction on your record. Please note that right now, many courts are not having in-person hearings due to COVID-19. The summons you receive from the landlord will probably not tell you how you should appear. Before you go to the courthouse, you should call the court or check their website to find out whether you should go in person or appear by phone or through an online meeting using a computer or your smartphone, something where you can access the internet for a period of time. Sixth topic, the answer form. If you feel that you have a defense of the eviction action, then you should write your defense or defenses in an answer and file it with the court. The answer is your response to the landlord's complaint. It does cost money to file an answer with the court. However, you may also file a request for waiver of fees, which is something you file to ask the court if they will allow you to not pay the filing fees, and the court may waive these fees for you or put you on a payment plan. Seventh topic, settlement agreements. It's also possible to work out a settlement agreement with the landlord or his or her attorney before your case is heard. A settlement agreement is a contractual agreement where you and your landlord agree on a resolution for the eviction dispute. Both sides have to agree to all of the terms of that agreement. For example, you and your landlord may agree on a payment schedule, giving you more time to make your rent payments. Settlement agreements are usually the best way to ensure you remain in your home without an eviction. However, be careful during negotiations with landlords or their attorneys. Remember that a judgment for possession equals eviction, so you should probably not agree to a judgment for possession unless you feel you have no other option. Eighth topic, trial. If you have a defense of the eviction action, the judge or magistrate may schedule a trial or a hearing for your case. In eviction cases, there may be 2 hearings. The first one focusing on possession, meaning whether or not you will be evicted. Then the court will hold a second hearing a few months later to figure out if either side owes the other any money. The first trial date, the possession hearing, can be as soon as your return date or up to 5 days later. At trial, the landlord must prove the allegations in the complaint by preponderance of the evidence. This means the landlord must show it is more likely than not that his allegations are true. A tenant also has to prove their defenses by preponderance of the evidence, or more likely than not. So what happens if you win your case the first time you have to go to court? If you win, the landlord does not get possession of your home. If you lose your case and the landlord wins, a judgment for possession will be entered in favor of the landlord. A writ of restitution, also referred to as a sheriff's move-out, is issued 48 hours after entry of the judgment. Ordinarily, the sheriff will not oversee an eviction on Saturday or Sunday. The sheriff can only remove you from the premises between the hours of sunrise and sunset, at which time the landlord can move out all of your belongings and place them outside of the home. If you do not retrieve those belongings within 24 hours, the landlord can dispose of them. Lastly, we discussed the 9th topic, appealing the court's decision. You or the landlord can appeal the court's decision. This requires you to file a notice of appeal and designation of record. The person appealing has to pay the appeal bond and the estimated cost of transcript. An appeal bond is an amount of money that the court holds while an appeal is being decided. For eviction cases, the appeal bond is usually the amount of the monthly rent payment. The estimated cost of transcript is a fee for preparing the record of trial for appeal. Once those steps are completed, the proceedings in the case can be stayed or halted until the appeal is considered. If stayed, you will not be evicted during this time. So that is a quick overview of evictions. Colorado Legal Services provides free legal services to low-income Coloradans. If you are facing an eviction or other civil legal matter, please call us to find out if you qualify. More information can be found on our website at www.coloradolegalservices.org. Thank you.